Hi, Texas voters. Welcome back to the third part of the series where we are talking about the 17 state constitutional amendments that will be up for our vote this November on the ballot. If you're new here, I recommend you pause and go start at the beginning of the series because each video is going to cover a separate constitutional amendment. Before we get started, I want to give a big thank you to everyone so far who's left a comment, asked a question, and engaged in the conversation in the first video. I can't express how valuable I find this to be. So with that being said, if you have comments, questions, or want more details about this constitutional amendment at the end of this video, leave them in the comments. Let's keep this conversation going. Every amendment is important, but I want to emphasize how crucial it is for you to spend a good amount of time deliberating with this amongst yourself and using heavy consideration when voting for this in the booth. This will impact every corner of Texas. I'm going to read the plain text of the proposition, that little blip you see right before you vote for it, and then I'm going to read the overview just to give a little bit more detail, and then I'm going to share a little bit more information with you. That way you have more of an informed decision as you go into the booth. Texas Proposition 3, the denial of bail for certain violent or sexual offenses punishable as a felony amendment. A yes vote supports amending the state constitution to deny bail to individuals accused of certain violent or sexual offenses that are punishable as a felony. A no vote opposes amending the state constitution to deny bail to individuals accused of certain violent or sexual offenses that are punishable as a felony. Overview. How would the amendment change who would be denied bail? The amendment would add the following list of offenses to the state constitution for which a person could be denied bail if a judge or magistrate determines that bail is insufficient to deter the accused from failing to appear in court: murder, capital murder, aggravated assault resulting in serious bodily injury to the victim or performed with a firearm, club, knife, or explosive, aggravated kidnapping, robbery and sexual assault, indecency with a child, and human trafficking. It would also allow denial of bail after a hearing and clear and convincing evidence if bail is deemed insufficient to ensure the safety of the community, law enforcement, or alleged victims. Are there any existing conditions or offenses where an accused could be denied bail? Section 11 of Article 1 of the Texas Constitution guarantees all prisoners the right to bail with the following exceptions: capital offenses, an accused who has twice been convicted of a felony, an accused who has committed a felony while on bail for a prior felony they were indicted for, a person accused of a felony with a deadly weapon after being convicted of a prior felony, or a person accused of a violent or sexual offense committed while under the supervision of a criminal justice agency of the state or a political subdivision of the state for a prior felony. Bail can also be denied or revoked if the offender is accused of a felony or an offense involving family violence and they violate the conditions of release. Have Texans decided on similar amendments before? Texas voters have decided on 5 constitutional amendments related to denying bail. The last bail-related amendment was decided in 2007. It authorized the denial of bail for individuals violating court orders or release conditions in felony or family violence cases. Now here's a little bit more info, that way you can feel more confident in the decision you're making. These are part of what was already constitutionally amended in order to be able to deny someone bail. In addition to the mandatory carve-out section 11 for capital offenses, the Texas Constitution includes 3 other provisions where courts may deny bail: sections 11A, 11B, and 11C. However, before bail can be denied, each provision has specific procedural safeguards that must be met. Section 11A applies to the following circumstances. Person is charged with any felony and one of the following circumstances exists. Individual has 2 prior felony convictions and the second conviction and offense occurred subsequent to the first. Individual was on a bail at the time of the new offense for a prior felony for which an indictment exists. The current offense involves the use of a deadly weapon and the individual has at least 1 prior felony conviction. Person is charged with a violent offense or sexual offense while under supervision of a state or local criminal justice agency. And then it lists what is considered violent offense: murder, aggravated assault with a deadly weapon, aggravated kidnapping, aggravated robbery, and then for sexual offense, aggravated sexual assault, indecent liberties with a child. And then it goes and lists the constitutionally entitled protections for the accused. Section 11B applies to the following circumstances. The person was released on bail for a felony or any offense involving family violence. Their bail was subsequently revoked or forfeited, and then it goes on to list those constitutionally entitled protections for them. Section 11C applies to the following circumstances. The person violated an order for emergency protection issued by a judge or magistrate after an arrest for an offense involving family violence. The person violated an active protection order rendered by a court in a family violence case. This includes temporary ex parte orders if served on the person arrested. The person engages in conduct that constitutes an offense involving a violation of such an order, and then it lists the constitutionally entitled protections for that as well. So to be clear, we already have constitutional amendments that allow for denying of bail to individuals who have proven to be a danger to the community. I'm going to read you a little bit more. Research repeatedly confirms that an individual's pretrial status shapes virtually every aspect of their case. Both detention throughout the pretrial process and detention of even a few days can have profound impacts on case outcomes. As a result, the decisions made in the hours following someone's arrest are among the most crucial. And just so you know, they've already placed extra restrictions on bails this year, passing it through the House and Senate and getting it signed by Greg Abbott. And so they've already have stricter limits on cashless bonds, and they also have the prohibition on public funds. Senate Bill 40 prevents public money from being used to post bail for criminals through nonprofit organizations. I absolutely believe in protecting and safeguarding victims. We just have to be careful because this will be used to target certain communities and create even greater inequalities within the legal system. With all that being said, just weigh this information to use conviction in your choice. Whew, that one was heavy. If you have any questions, comments, or want more details, leave it in the comments and I will do what I can for you.